Hello and welcome to the podcast of the Prison Officers Association, the UK's largest professional union for prison, correctional and secure psychiatric workers with over 30,000 members. In this episode, we discuss what happens when there is a death in custody, the subsequent inquest at the Coroner's Court, and how members can best prepare for that. Later, we will hear from Keith Shepherd from Thompson Solicitors, who will walk us through the entire Coroner's Court process. But first, POA Branch Officer Laura Byrd on her experience of a death in custody and why POA membership is so very important in such difficult circumstances.
I joined the prison service in 2015 as an OSG in Eastwood Park. So I kind of wanted to go into the police at first, then I got swayed and I thought, well, I'll join the prison service because I do want to work with offenders. So then I had a taster as an OSG and then I thought, well, I can do the officer, so I'll go for it. So I did my officers at Newbold, did the training, and then I went to Downview in London, which is another female jail. And I stayed there for 2 years and then went back to Eastwood Park and I've been there since 2018. I can't speak for being in a male prison. I think probably being a female officer in a male prison is very, very difficult. But I love my job. It's definitely thankless at times, very stressful, but I love it. I do love it. And working as a female with females, it's definitely got their issues because I know I've got my issues and females express themselves in crazy ways, but I love it. I would say when I was in OSG, I was definitely a bit naive and I didn't join the POA. I was like, I'm not a prisoner-facing role and I'm not sure if it's relevant to me. And then quickly I realised it definitely is relevant. So I joined when I did my officers and I signed up in the training. And yeah, it's so important. When I was in Downview, that was in 2017, I found myself in a really sticky situation. Death in custody, a lot of details. I won't go into it, but it developed into this huge case where I got a phone call one day saying that I was being charged with gross negligence, manslaughter. I was suspended then and actually on bail until the trial. I mean, I can laugh about it now, but it wasn't funny at all. They supported me from day one. Obviously, the trial was huge and it incurred a lot of legal fees, which I would be in no position to pay for myself. They supported me the whole way. We had a good solicitor, barrister, a QC, and you think that would have put me in so much debt. Like, my parents are working class, they wouldn't have been able to afford without going into debt themselves. So yeah, I owe them my life. I literally really do. Amazing. So Thompson Solicitors were exceptional. Like, the service they provided for me was amazing. Keith Shepherd was the solicitor. And oh God, I owe him so much. I'll never be able to put into words how thankful I am. His caseload was huge and he put so much work and time into building this huge case, which obviously we come through in the end, but he's brilliant. I'm a bit of a poster girl now because all I have to do is walk into the office and I'll say, if they're not in the union, and I literally say, do you want me to tell you my story again? And they're like, no, I realise that. But you just are naive and you never think that you're going to find yourself in that situation. But it happens, and the responsibility we've got in our job is crazy, and it only takes one little mistake. You could be really the best prison officer ever, but that one thing that you didn't write down or that one door you just didn't lock properly, and that's it. It just snowballs into something big, and when you've got the union behind you, they'll fight for you.
Thank you, Laura. Now, Keith Shepherd from Thompson Solicitors with a practical, step-by-step guide to what happens when there is a death in custody and the whole Coroner's Court process. We're here today to look at Coroner's Courts and the inquest that takes place within them. And the starting point is that if there is a death in prison, then in England and Wales, it's a legal requirement to have an inquest. So, Keith, I suppose the starting point is what's the purpose of the inquest?
The purpose of the inquest that the coroner will look at is to ascertain who the person was that died, where they died, the time of the death, and how they died. And the fourth point on how they died in a prison environment is the most important questions, where it goes into the circumstances of their stay in custody, and they look into the care that was afforded to the deceased prior to the death. And it's a legal requirement for all deaths that occur in prisons to be subject to an inquest.
Okay, so we'll come to what it's like to actually attend one of these inquests and potentially to attend as a witness a little later on in our discussion. But for the time being, let's find out more about the inquest itself. So who are the people that are involved in an inquest? The coroner, obviously, because it's the coroner's court, but who else is going to be in the room, as it were?
The coroner does preside over the proceedings, but just for information, a coroner is an independent judicial officer who is normally qualified as a barrister or a solicitor or a doctor. You know, they can come from different backgrounds, but the setup in a coroner's court, you do on occasions with Article 2 inquests, which are more detailed inquests, have a jury that would be the same as a jury in a criminal court. Now, it's a legal requirement to have a jury for any deaths that take place in a prison. However, most recently, the coroner's rules have changed to state that there is not a requirement for a jury to preside over an inquest where the death is one of natural causes. However, all self-inflicted deaths are subject to a jury. The representatives of the different parties, which are anyone who has a general interest in the death, may, at the discretion of the coroner, be legally represented. So we're talking about people like members of the family. The prison service will have legal representation, and also any other person that's deemed a properly interested party, which can include individual prison officers. But we tend to see a lot of medical doctors, etc. And anyone that has a general interest in the inquest can be made a properly interested party and have legal representation. The coroner does call witnesses, which are made up of people that are in any way, shape or form connected with the person that died or was involved in any way with the circumstances surrounding the death, that may be called by the coroner to give evidence. And their role is simply to relate any relevant facts to the coroner and jury to help them reach a conclusion. Now, with prison officers, they are ordinarily called as witnesses, and they are, in the first instance, required to attend courts if so asked by the coroner, to assist with any information that they have regarding the circumstances and interventions that were made in respect of the deceased. And the other people that are involved are the public. An inquest is a public hearing, so anybody can attend, and you will always get members of the family. You can also see people that have an interest in the inquest, including members of the press.
So we've got all those people in place in actually in the court, and I suppose the next thing to consider is the evidence. What is the evidence that gets brought forward, and what can the court do with it? They can't decide who's responsible, can they, or can they? No,
the coroner's court is not there to consider evidence and apportion blame at all. It's an inquest are not a criminal court where they can decide who is responsible for the death, and from the evidence that they have before them, they will use that evidence quite simply to identify, the coroner will identify the facts of what actually happened in order to identify the purpose of the inquest, which goes back to the questions that I mentioned at the start that the coroner will be asking: who died, where they died, the time of the death, and how they died. So the evidence can be used at an inquest in the prison environment would be the file of documents and papers that have been received from the prison. So we would have the records of the deceased and anything that was relevant from their stay in custody. That could make up maybe a number of documents in connection with their stay. And we're talking about documents such as the suicide and self-harm documents, any other documents that really relate to their time spent in prison that are withheld on any of the systems that the prison service use. And also, after the death has taken place, the prison and probation's ombudsman will go into the prison and interview members of staff and anybody in connection with the deceased. This is something that does take a considerable amount of time, and the prison and probation ombudsman will speak to a number of different agencies within the prison service in order to ascertain the interventions and any detailed communications as such with the deceased. There are obviously evidence documents that can be obtained, i.e. anything that's relevant even from before the incarceration, and any medical reports or records that may have accompanied them to wherever the individual did pass away.
Before we go on to talk about how the facts are established or what level of proof is required, the prison service ombudsman, is their investigation subordinate to the coroner's court, or is it an entirely separate matter?
They're totally independent, but they themselves can end up being called by the coroner, even though they provide a full report with the annexes, and the annexes are the witness statements or anything that's relevant to their investigation. But it's very, very detailed, and the coroner uses that document in order to really question witnesses that attend and question properly interested parties. But the coroner uses that document to give a full sort of overview of the deceased stay in custody. And the author of the report is ordinarily called at times by the coroner to come and give evidence in respect of the report. Is asked questions by parties.
I suppose, therefore, anyone who's interviewed by the ombudsman as the individual needs to bear in mind that the ombudsman report will be seen by the coroner, and therefore anything they say to the ombudsman, they must bear in mind it will be at least seen by the coroner's court.
That's 100% correct, yes. And the evidence that they give in their witness statements will be relied upon at the inquest. So it's very important that they provide a very detailed and a clear account of their involvement with the deceased, because that statement is going to be not only relied upon by the coroner, but all of the interested parties will have copies of the statements given by the officers, and they will be questioned if asked to attend an inquest on the content of those documents.
Okay, we'll come to the process of actually giving evidence a bit later on in the discussion. Now, the facts that get established in the coroner's court, is that to the civil standard of proof, which is the balance of probabilities that something happened, or is it the kind of higher criminal standard where things need to be proved beyond reasonable doubt?
Generally, the facts are established to the civil standard of proof. So, yes, you're quite right. It's known as the balance of probabilities rather than the criminal standard beyond all reasonable doubt. But there are only two exceptions to this rule, where there's been an unlawful killing or the deceased took their own life, where the evidence must satisfy the criminal standard of proof.
So the evidence has been submitted and has been weighed. What are the possible outcomes that can come from a coroner's court hearing?
There are a number of conclusions open to the coroner, or the jury as well, if there is one. As I've said before, the purpose of a conclusion is not to identify or apportion any blame, but in the first instance, the conclusion will explain the circumstance or how the person actually died. So an example would be of natural causes. If somebody died of a heart attack in prison, that could be a conclusion to the inquest. They took their own life is another common conclusion where it was a self-inflicted death. And in addition to that, it can be given as a conclusion that they took their own life whilst their balance of mind was disturbed. And the word suicide is not ordinarily used. Another conclusion is an accident or misadventure, which is described as the unintended consequences of a deliberate act. Whilst the coroner can give those conclusions, they can also have a neglect rider to them, insofar as that can be attached to them, and they can provide an additional explanation as to why they feel that the conclusion should have a neglect outcome proven to the civil standard attached to them. And an example of this is that if a death happened in prison, the inquest can find that there was neglect on the part of the prison service, which directly caused or contributed to the prisoner's death. However, going back to what I said previously, it still cannot name any individuals or their acts or omissions that caused the death. Those list of conclusions are not exhaustive, insofar as that there are other verdicts, such as unlawful killing, which includes both murder and manslaughter, an open verdict where there was insufficient evidence to prove any other verdict, and a what's called a narrative verdict, which allows the jury to add comments to their verdict, which is exactly what I've explained to you for a neglect outcome.
If a coroner's court was to return a conclusion that included a negligence clause, or if they were to conclude that there'd been an unlawful killing, presumably there would be consideration of criminal charges to follow that if they'd identified an unlawful act.
That is correct. And if there was an unlawful act that was identified during the inquest, it's open to the coroner to ask the police to reinvestigate if there was any criminal act. Ordinarily, the police have primacy over any death in custody to investigate and to make sure that there's been no unlawful acts. And ordinarily, they will conduct their own investigation, if so required, before the actual inquest. And the coroner must wait until the police have completed any investigations in the first instance to identify whether or not any individual should be considered for an investigation or any criminal prosecution.
Given that these are public hearings, and given the nature of the hearings, the media are going to be often involved and present actually at the court.
Yes, they are quite often in attendance at the coroner's court.
The media being present could pose some challenges. What's the general advice that would be offered to members of the POA who have been in court and given evidence as a witness? Members
of the press do attempt to speak to witnesses who have given evidence, and it's our advice that they should not participate in any interviews either during or after the inquest is concluded, and they are certainly not allowed to talk to anyone until after the inquest is actually, or they've given their evidence and it's actually concluded. We advise members that they should refuse politely to speak to any members of the press who approach them, as it's not advisable given the press's stance on what they are reporting, and which is ordinarily very negative towards the prison service and the staff.
Yeah, so I think a polite refusal is probably the best way to summarise that, for both for legal reasons, because it would be sub judice if the case was still ongoing, and because actually the press are probably not interested in the same things as the coroner's court or the POA themselves. Right. So that's the process of the hearing. Now, if we turn to the role of individual POA members, obviously we've discussed how before they get to the hearing, they'll have probably given a statement to the Prison Service Ombudsman. They may have given a statement to the police. How should they prepare for the hearing? First of all, how do they know that they'll be required to attend the hearing?
They will be advised through the prison service, through their employer, ordinarily safer custody, that they are required to attend an inquest. If that doesn't, which normally does, they could receive a witness summons through the post. Now, if a POA member is requested and asked to attend an inquest, they could be asked in advance of attending to give a further statement to that of what was given to the Prison and Probation Ombudsman, if the coroner wants any further questions asked that's maybe not covered within that statement. And it is the case sometimes that the Ombudsman may not have interviewed every single person that's required to attend the inquest as a witness. So that statement is normally taken in advance, as I said, of the inquest, and is either done by the police and or an officer from the coroner's office. But ordinarily, the coroner may ask the Prison and Probation Ombudsman to take further statement as well.
So they receive a summons. Do they themselves have to inform the employer that they're going to be absent from work in order to attend the court?
All of the arrangements for the attendance at court, whether they are being asked directly by the court or they're being asked through the prison service themselves to attend, will make sure that the governor will make sure that they are given sufficient leave to attend an inquest. They will be spoken to about the contents of the requirement to attend the inquest and prepared to give evidence at an inquest.
So part of that preparation presumably will be making sure they've reacquainted themselves with whatever statements they've given in the past. So I guess, would you advise people to keep copies of all the statements that they provide so they're able to do that?
Yes. When they actually give a statement to the Prison and Probation Ombudsman, they should actually be given a copy of what they've provided. And yes, they should keep a copy. But any statement that they have made will be in possession of the legal representatives. So the prison service will have legal representation in the form of a barrister attending the inquest. And ordinarily, the members of staff can be represented by the prison service barrister at the inquest, who will be furnished with all of the evidence in the case. And prior to attending the inquest, the witnesses, i.e. the prison service employees, will have a full conference with the barrister and the government legal department in order to prepare themselves for giving evidence at the inquest. And they will be supplied with copies of their statements that they've made, whether it be to the Ombudsman or to a police officer.
So there will be a conference with the legal representatives at which the POA member will be briefed on procedure, reminded about the statements they've put in. And I suppose, crucially, any kind of procedurally or statutory required documents will be part of that bundle and part of that discussion.
Yes, when these conferences take place, which are ordinarily at the prison, they will be attended by the government legal department and the barrister who will be representing the prison service. And the individual members of staff will be given copies of any statements that they have given, along with any documents that are relevant that they may have made entries on. A very important document would be what's called the ACT document, which is an assessment, care in custody and teamwork document, which is a very detailed document where checks are made on an inmate where somebody is considered to be at risk of suicide or self-harm. So the POA member has given their statements, they've been reminded of their statements, they're primed and prepared, as it were. It's the day of the hearing and they turn up at the court. Where do they go? Who do they speak to? They will be met by either somebody from the prison service, and ordinarily they will have a liaison team at the court, and they will also again speak to the government legal department, who will be there to make sure that everything runs smoothly, and also the barrister that they've already spoken to will be there as well. They will direct people to where they should wait, and when they are required to attend court and go into the witness box, they will be told where they should go and where they should sit, and everything else. Now, the government legal department will, in their conference with the individuals, give a full explanation as to what is required of them on the day. And on occasions, they may even facilitate a meeting at the coroner's court, prior to them giving evidence, so they can see the layout and what's actually required. But that will be down to the individual prison and the government legal department as to whether or not they're going to provide that. But it's something that I would always recommend any individual go to give evidence at the coroner's court to go and see where they're required to go, so they can get a feel as to what's going to be required of them.
Right, sound advice, I'd say. So the officers of the court have come forward and they've asked the POA member to go into the witness box. They've been called to give evidence. What do they do? What do they say? Can they stand up? Do they sit down? What if they can't stand for long periods of time? What exactly are they going to experience once they get into the witness box?
The coroner wants them to be as comfortable and relaxed as possible, and they are able to, ordinarily they're able to sit down to give their evidence. However, they can ask for that from the coroner, but the coroner may ask them to stand, and they should, when they give their evidence. But because ordinarily they could be giving evidence for some time, the coroner normally says that any witness can sit in a chair in order to give their evidence and make sure that they're as comfortable as they possibly are.
I mean, it's not a criminal court, of course not. But do you still have to swear an oath before giving your evidence?
Yes, any witness will be asked to swear an oath on either the Bible or another holy book. But if they don't want to do that, they can ask. They will be asked to affirm, which is the promise to tell the truth.
And then presumably the questioning starts.
That's right. The coroner will start the question as such, and what he will ordinarily do is to go through the any statement that the witness has made and ask a simple series of questions. And following on from those questions, the various legal representatives who are present may also ask them questions, along with members of the jury.
And in terms of just like who you should look at when you're answering the question, I can imagine if there's a jury, the jury's making the decision, so you address your answers to the jury. But if a legal representative is asking you a question, do you look at them when you reply, or do you always look at the coroner because it's the coroner's court?
Ordinarily, witnesses should look at the coroner when answering questions, and unless they're obviously in the case where a jury is asking them, they can address their answers to them, no matter who asked the question. But ordinarily, the witness is facing the coroner, whether sitting down or standing up, and any questions that can be asked from around the court, the witness should remain in the same position and direct any responses directly to the coroner.
So, Keith, what's the best advice that can be given to people who are in the witness box giving their evidence?
Witnesses who are required to give evidence are advised that they should speak loudly, clearly, using short and simple sentences. There are a number of things when providing evidence that they should stick to, and they should make sure that they are giving direct responses to questions and not be tempted to volunteer information. The witnesses must provide clear responses to questions because they are going to be recorded, and obviously should avoid nodding or shaking their head in a reply to a question because the audio recording equipment will not pick that up. It's also very, very important that any witness must answer the question actually being asked, not what they think they are being asked. And if they're not sure as to the answer to a question, it is totally valid for them to say, I'm not aware of that, or I can't answer that question. As I've mentioned before, they've got to they must tell the truth and try not to give the right answer in a scenario where they're asked a quite tricky question. And if they don't know what the right answer or any answer for that fact, they should say so. If any witness does not understand what they're being asked or didn't hear the question properly, then they should ask for it to be repeated. And similarly, none of the witnesses should be rushed into answering any question. And if they feel that they can ask the coroner for some more time. But it's very, very important for any witnesses giving evidence that they are not pushed into maybe getting rattled or angry, and most certainly should also avoid giving what I call clever answers in response to any question that may come from the representatives for the family, and that they must just be clear and give short responses.
So, yeah, I suppose as well as avoiding giving what I think everyone understands what you mean when you say clever answers, it's got to be a factual response, hasn't it? The witnesses have got to avoid like opinion or insinuation.
And that does happen quite a lot. You're quite right. The witnesses should answer questions with facts only, and you may get a representative from the family making insinuations as to what potentially happened or why they conducted something the way they did. So witnesses have got to be clear about giving their responses and ignoring any insinuations that have been made from any representatives. And that goes for the same with witnesses thinking that they did not explain something clearly, or if they've said something that's misleading, then they should say so at once.
But of course, choice of language is very important in other ways as well, isn't it? Because slang or jargon is part of everyday working life, whatever your occupation or profession. But that won't necessarily do for a coroner's court. That's
right. It's really important that all witnesses are very sensitive to the situation, because obviously the inquest is about a death, and the family are going to be present. So they mustn't refer to inmates as any slang or any prison service jargon that they may use whilst working. And witnesses should refer to the deceased, importantly, as Mr. or Mrs. with the surname, and also when addressing the coroner, they respond as sir or madam.
Right. Well, I mean, I think that's tremendously useful, practical set of points. But once they've given their evidence, can witnesses then just leave the court building and make for the nearest cup of tea to just reflect on what could be quite a lengthy and challenging process, or do they need to hang around?
Ordinarily, the coroner will, at the end of their evidence, advise the witness that they are now released, and they will be told that they can leave the witness box, and they will be given the direction from the coroner. But if there is any matters that the coroner wishes to ask them about, then they could be advised to stay in the building if any further information is required from them, and that they shouldn't leave without express permission from the coroner. However, ordinarily, after a witness has provided evidence, they are normally released and can either leave the building or go back to work as directed by their employer.
Thank you, Keith. And the message is clear. When dealing with the upset of a death in custody, even one where the facts of the matter are clear and not disputed, prison officers need the support of their union and the legal services it provides. This is a key way in which the union is working hard to make sure the workplace challenges faced by members are understood and, wherever possible, controlled, and that members get the support they need. Truly, the union is only as strong as its members, and the more members the union has, the louder and stronger the union's voice. So, if you're listening to this and haven't signed up, speak to your local POA rep, or head over to poauk.org.uk to find out how to join and all the information you need about the union and the work it does supporting members called to give evidence in the coroner's court and everything else. Thank you to Keith and Laura for joining us on this episode. Thank you for listening. We hope you like what you've heard and will join us for the next episode of the POA podcast. Thanks and